So tonight we have two panels. The first panel is going to look at how slaps impact media freedom. We have a brilliant panel, and all of the cases that are mentioned tonight are included in the report. So we're starting with Claire Castle-Brown, who's the founder of Sarawak, and who's faced some of the harshest legal intimidation that we've seen. We'll then move to Paul Caruana-Galizia, who's a journalist at Tortoise. He's also the co-founder of the Daphne Caruana-Galizia Foundation in Malta, and his mother, Daphne Caruana-Galizia, and indeed the foundation, and Paul have all faced slap suits. So you must be probably the most slapped family, unfortunately. So Paul can really highlight not just the issue here in the UK, but also the connection to Malta, and the many cases that were taken through London libel firms against not just Paul's mother, but also journalists in Malta. And then we have Peter Gagan, who's the editor-in-chief of Open Democracy, and Peter himself has faced slaps, some really interesting ones, which delve into Northern Irish politics, and I'm not sure if my mic is still on, but yeah, it's okay, brilliant. So we'll turn to Peter at the end. So Claire, I wonder if we could start with you. Could you explain the cases that you faced, during the UK, the continuing legal threats against you, and just give an introduction to what's been going on?
Gosh, well, I've had dozens of legal threats. Most of them don't get to court. They're trying to bully and intimidate you effectively to stop talking about their clients, or preferably remove anything you ever said about your clients. Otherwise, it's going to become very expensive. This is just the meat and potatoes, really, of doing any investigative work. I have recently been engaged in unraveling a multi-billion, multifaceted scandal involving a major kleptocracy in Malaysia, which has taken me into multiple jurisdictions, but it's involved several threats and cases against me here in London, including one full-blown court case, which involved me in hundreds of thousands of pounds of legal fees, indeed, if I had lost that case, we would have been in over £2 million worth of costs to me personally, if I'd lost. So what was that about? It was about something that I believe I haven't said, about someone who I didn't write about. The essence of a slap suit is that the litigant will tell you that in their opinion, you meant something. And if you want to say you didn't, well then we will take you into the High Court, and it will be months of highly costly, legal to and fro for you to prove your case. And of course I have to then, I find myself in a position of having to prove something I didn't think I said about somebody who wasn't mentioned in an article. So it's a great game. It's a toolkit to bully journalists and media organisations into giving in. And in fact, in the particular case I'm referring to, I happen to know through inside sources that the London law firm involved had assured the litigant that after £2,000 worth of their expenditure, I should have been crushed and I would have settled. And that would have been very convenient for them politically, because they were trying to discredit me in advance of an election in Malaysia.
But instead, Claire, you continued.
Well, yes, I did, because a nation's future was at stake. I needed to stand by the truth of this case, which has in fact resulted in the conviction of the Prime Minister of Malaysia. So I stood my ground, which put the roof over my family's head at stake, to put it mildly, and indeed my our financial future.
And did you win any of those costs back in the end?
Yes, I did. Not all of them. And the first thing you're warned is you'll never get your money back. So a few tens of thousands of pounds, nothing in the case, but it's a lot to the defendant to be out by a few tens of thousands of pounds.
And how long in total did the process take? Because I think that the length and the duration of these processes really wears people down.
Yes, it's an attrition, and of course what it does very effectively, because the first thing your lawyer very sensibly tells you is not to talk about the case once it's in court, and so therefore you've been muzzled. So that's one of the objectives of these lawsuits is to and you can silence a journalist for years as they drag through one of these cases, and a news organisation. And all this is wrong. These journalists do sometimes say things wrong. They can be malicious. It's been known. But this needs to be settled expeditiously, effectively, and it needs to be available to everyone, not just the super rich.
Yes, and it's this what we call the inequality of arms, that the defendants have so fewer resources than those taking the cases against who they can afford.
Well, unfortunately, I mean, if you're doing your job as a journalist, you're looking at the super rich and powerful, because this is you're looking at what's in the public interest, and so they may not like it, but they have a lot of influence over everybody else's lives. So they deserve a need to be legitimately questioned and scrutinised and held to account. But they wield enormous power, and they use that to mobilise against coverage. And you can't have a democracy and not be and have a press that can't talk about the most powerful people.
I think your case also highlights you were on your own. You didn't have a big media organisation behind you. So how did you find legal support, and how did that process?
Well, I was supported by one of our best law firms, thank goodness, who took on my case, and were very gracious in helping me through that. But yes, for lone journalists, it's extremely difficult. I would say, ironically, to an extent, because I knew I had a very important case to fight in this respect. Because I didn't have to answer to an editor and a publisher, I could make the decision to stick it out. I've also worked for several mainstream news organisations who'd rather not touch these sorts of stories, because they could have dozens of these cases on their hands, and do, and so they seek to avoid getting involved in these cases. And again, we're looking at the situation with all the issues about oligarchs now. Where issues that should have been confronted many years ago, which journalists were itching to write about, they couldn't.
And here we are.
And here we are with the consequences of nobody knowing what was going on. Not enough people.
Moving to Paul, so one of Paul's most recent reporting has been exactly on this issue of the oligarchs here in London. And Paul, in the course of your reporting, you faced some of your own legal challenges.
That's right. So the last piece was on a member of the Lords called Greg Barker, who until recently worked for Oleg Deripaska's big aluminium conglomerate. So the interesting thing about him is we first reported on him 3 years ago, and he really wasn't a fan of the report. And so a day after we published, we started getting these really long, very aggressive letters from Shillings, who said they acted on his behalf and on the company's behalf. And in many ways, they were the kind of usual thing, which I'm sure you talk about in your report, long, aggressive, threatening, all sorts of things. But on that, the most unsettling thing I think they did was start going after sources who went on the record in the piece, including bizarrely a portrait painter. So I interviewed a man who painted this absurd portrait of Barker, and he started threatening or Schilling started writing to the painter on Barker's behalf, saying, what you said in this piece is defamatory. You shouldn't have passed this portrait on to Paul. We'll sue you unless you sign a statement renouncing everything you've told Paul. And what do you know? Here's the statement. Yes, and he never did, thank God. But I thought, how extraordinary, that they go after sources in that way, and do almost exactly what a lawyer, at least in this area of work, is not meant to do, which is to completely distort the truth and to disinform. It went nowhere. They just dropped it. It actually went on for about a year and a half, and we had to pay our own lawyers. Our insurance premiums shot up, but he never sued in the end.
And I think you mentioned that Schilling's for 4 legal letters were charging
40,000. That's right. Yeah,
it's 10 grand a letter.
Yes, that's right. It was unbelievable. The fourth letter came in and said you're looking at legal costs of. It was more. It was closer. It was 40 to 50,000 pounds. And some of the letters were really, they're all the same. You breached our client's privacy, copyright in this case, highly defamatory. It just went on, and every letter was the same, never ending, 10 pages long. And once by accident they sent one that had a draft watermark stamped on it. And we wrote back to them and said, did you mean to send it? And he wrote back another 10-page letter, but it started, you're wasting our client's time. It's just really absurd. Yeah.
So we see sort of the money machine as well behind this, right? That it's quite a lucrative area of business. And that's something that I think we've been trying to draw out a lot in the report is looking specifically at why London, why is it not, in the same questions that you asked in your podcast, why is it London, not Madrid or Paris that has become this hub? And maybe if we could talk about your mum's cases, it was also a lot of those cases were coming from here.
That's right. So the first letter she received were from Mishcon, their area. And again, always the same thing. In this case, they were acting on behalf of a private company called Henley & Partners, which has a monopoly over the sale of Maltese passports. So my mother reported on the scheme, the company, the way they sold passports to oligarchs, corrupt officials. Anyway, and the letters started coming actually just a few months before she was killed. But the main thing about them, like you said, they're meritless. That's the word, merit. But the main thing about them is, I remember that the phrase they use is legal action against you in the Court of England and Wales. Why specify unless it's all about the costs? It's all about England and Wales. And my mother was facing 47 libel suits when she was killed. Right? She was used to it. 5 of them were criminal. But it was this threat of this jurisdictional threat that caused her the most anxiety, because it's one thing. So Malta costs are very low, which explains the high volume of suits. But but having the thought of having to pay to defend yourself in England. A Maltese journalist, right, reporting on a Maltese story for a Maltese audience. Suddenly, she had to face, the threat of defending herself in England. And she was killed not long after. But then I remember my brothers and I were looking or trying to understand why on so many stories she appeared to have been isolated. Why, in other words, a lot of other Maltese media houses weren't reporting on the same things. And we found that they had received similar letters, only they complied. They complied and didn't say anything about it. In a couple of cases, they actually edited their online pieces without even acknowledging that they had done so. Really unsettling, really creepy. And then, why? Why did they comply? Because a lot of these letters, many of them from Schilling's, on behalf of a banker, so a laundromat actually, Pilatus Bank, which was shut down, threatening enormous costs and damages. And although these are Malta's biggest papers, so Times of Malta, Malta Today, Malta Independent, there's no way they could have even considered defending themselves in England, I think. So that's all it took, you know, the letters. And they just completely blacked out a couple of stories in that way.
And I think just in terms of the costs, what we see is, you know, even to begin to defend yourself here, it can be around 350,000 starting at that level, and you may not recuperate the costs, as in Claire's case, until a long time afterwards, even if you win. So it's this extended case where you have to put up the money at the beginning. But what your mum did, which was really unusual at the time, was she published those letters. She published the threats.
Yes, that's right. So they all come marked private and confidential. And so my father's a lawyer, and she asked my father, are they really private? And he said, no, they're your property. You can do what you want with them. And she said, right, and she started publishing them. Which shows, you know, maybe it's not always advisable, but it worked. You know, it exposed the letters for what they are, just threats, and it embarrassed their clients. You know, their clients suddenly were exposed in this way, to have hired these lawyers to threaten her, and it all sort of started falling apart. And I thought, if it had merit, if the letters had merit, then it wouldn't. You know, you wouldn't be embarrassed of them. You wouldn't be ashamed.
And I think that's something that we really encourage journalists to do, is to publish these letters, because there is a very understandable tendency to either comply, because it's kind of frightening, the financial and the hassle involved in all of this, right? I think that we talk a lot in the report about the psychological pressure this places on journalists who've had to put their house on the line or life savings. But there's also just this time pressure. And I think you've also spoken about that with your mum, that her last year was really taken up with fighting these cases.
Yes, I mean, again, there were a lot of suits, and you know, every time she'd have to go to court. Often the claimant wouldn't turn up. You know, you'd have another hearing. Often nothing gets done. You know, the magistrate is sometimes late. And it was just, there was a period I remember where she was just always in court, waiting around. And actually, not many, so of course the 5 criminal suits dropped when she was killed, but most of them carried on. So we in effect inherited them, because they continued seeking damages against her estate. And actually most carried on until very recently. You know, up until 3 years after her death, we are still looking at 20-something suits.
Which made it so unusual. I mean, it was so unusual what happened in that case, that so many of the leading world experts were refer to this as just how egregious Malta's system was, that this was even allowed to happen, these posthumous cases. And I think, at least in some of the reforms that have now gone through, at least that one part has been reformed. But we're still waiting to see much bolder reform in Malta, and that remains to be seen.
Yes.
And Peter, I think one of the really interesting parts about your case is Northern Ireland, different jurisdiction, even more limited reform until very recently. Could you tell us a little bit about the case that Open Democracy faced?
Yeah. So we at Open Democracy, we are used to a bit like Paul and Claire used to getting lots of legal threats, and I think it's been so refreshing, like, have an opportunity to say, because we did. I wrote about it last year. Quite reluctantly, actually, because I felt like writing about yourself.
Yeah.
And you feel like you're not, you know, I feel like not the thing to do. But I've received lots and lots of legal letters over the years. I'm normally for the jurisdiction of England and Wales. But in 2018, in kind of the middle of 2018, I'd written a series of articles about the Democratic Unionist Party, DUP, in Northern Ireland, and various aspects of their funding, political funding, and other aspects of the party, and senior figures of the party. And around the middle of 2018, I got a legal letter from an Northern Irish law firm after we wrote a couple of stories about Jeffrey Donaldson, who is now the leader of the Democratic Unionist Party. And it was kind of interesting because I'd never actually had legal letters from Northern Ireland before, so I hadn't quite realised just how different life in Northern Ireland is, in many respects, despite working there for a time as well. And the long and the short of it is, basically what happened was we ended up being sued as Open Democracy. I was sued personally as well by Jeffrey Donaldson and his brother for defamation, for all the same kind of reasons that both Paul and Claire have elucidated. All sorts of meanings read into things that people have told us as well. So kind of implicit, like they didn't threaten to sue our sources, but they kind of suggest that the things our sources had said were defamatory as well. All the various aspects of this in various legal correspondence. And this went on, and what's interesting was the tactics that happened with this. It's like, we're going to sue you. It's going to be very costly. You can settle now and save yourself some of the expense, but we're going to sue you. Different jurisdictions have different kind of statutes of limitations. So just, I think it was the day before the year, you have a year to file a suit in a Belfast court. There's a kind of almost a pro forma document you can put through that kind of kicks it on for another year. And so technically we were sued, although it never went to a court. It was never heard by anybody. But it went on for another year then because it was moved into, they managed to get, it's basically, you can expand and elongate the process. All the while we're getting these legal letters constantly. We're a small remedial organisation. We're having to pay lawyers, to pay legal representatives. We had to pay specific legal representatives in Northern Ireland who were au fait with the Northern Irish defamation law to deal with these letters. It cost us a lot of money. As same thing happened as seems to happen with you, Paul, as well. Our legal insurance went up through the roof. Our legal insurance went up threefold last year when I just wrote about it. Even though I wrote about the fact that the case was over and no one had sued us successfully, the very fact of writing about it increased our legal costs. But the other thing that happens as well is the opportunity cost of doing this. It's incredibly time consuming. I'm now the editor-in-chief of Open Democracy, so I deal with these letters almost on a daily basis. And one thing that happened with this story, and I will admit this happened with this story, you're silenced by it. There's other stories that you look around and you go, oh, it's okay, story, it's not that strong. You can't find reasons not to write more stories about these people because they're trying to sue you. That's just the reality that happens. But the other thing that happens as well, I've noticed, and I'll return to the DUP story in a second, is that you publish a story and a legal firm, a blue chip legal firm will contact you, and they're not actually threatening at that juncture to sue you, but they're asking you all sorts of annoying questions and making it clear that they think what you've written is defamatory. And especially if you're a small organisation, in dealing with all that, you can't follow up your own stories. You're so busy having to deal with these legal letters and these legal threats that come, and this happens to me all the time now. But what was particularly interesting about Northern Ireland is that Northern Ireland never had defamation reform. And the reason why is back in 2013, there was supposed to be reform. There was reform in England and Wales. A lot of people at the time thought it was going to be great. A lot of people like us talk about, sit on panels like this and talk about why it hasn't been all that great, why it needs to happen. But Northern Ireland was supposed to grandfather in this legislation, which is kind of what it does with a lot of devolution stuff. Scotland is different, but Northern Ireland was going to grandfather in the legislation. And then, quite literally in the middle of the night, Sammy Wilson, who's a DUP, now DUP MP, but he was a DUP's culture minister at the time, he nixed this in the middle of the night, basically. They got rid of it. He used a petition of concern, which is a mechanism, the Good Friday Agreement, which is supposed to protect parachute esteem, really had absolutely nothing to do with defamation. He used that to stop any reform of defamation in Northern Ireland. So 10 years later, there is now a bit of a head of steam built up in Northern Ireland through great work from, I'm sure, colleagues and people in this room, and it is starting to happen. But what you have in Northern Ireland is, for a very long time, as one very prominent Northern Irish journalist put it to me, what you have is political parties treating newspapers as ATM machines. And they don't go to court because it's very, very expensive to go to court. And they all know this. And there's incredible numbers of cases in Northern Ireland that are settled out of court, huge amounts of money changes hands. And they're not reported on, they're not discussed, they just happen. For a lot of the same reasons that newspapers, people who run newspapers or Redditors are not often bad people. They do sometimes care about journalism, but they either, they have bosses who really don't want the headache of this sort of stuff. They do not want to hear it. It's incredibly expensive. And they will also go, we've got some insurance, it's going to cost a fortune to go to a court, and they will just, they will relent and pay out. So it's a really iniquitous situation. And for us, it costs a huge amount of time, costs a huge amount of money, and really for a small organisation like ours, and a lot of stress as well. It's very stressful for journalists. It's very stressful for people who are doing this work, and it's all intentional. That is what this is all about. It is not it's not an unfortunate byproduct of this. That's exactly what happened. And it's interesting, in all of these cases, we're not talking about people who ended up in a courtroom and lost their house on the back of it. That didn't happen to us, and I don't think it's happened to anybody else in this court, on this stage. So, and we're not the only ones who have this experience. I think it would be very different if what you were talking about was regularly people are going to a courtroom and losing, and therefore they're in huge trouble. They've done terrible journalism, but that's not what's happening, and that's not what this is about. People have reputations. It's fair that their reputations should be protected. I think lots of journalists agree with that too. But this is not, as I say again, this is really what this is about. It is about stopping people reporting. It's about stopping people telling stories that need to be told, often in the public interest.
And that's the strategic element, right, of the whole thing. I'm going to open it now to the audience. I just have one final question from me, and that's really to ask your view on the reputation management industry here in London. What your experience has been of it, how you, if you have any ideas for how it could be reformed. And I'll look at that more in the next panel, but there is this obviously growing awareness, especially in light of the war in Ukraine, of the role of the enablers here in London. But where do you, I mean, from your experience, what has been your experience here with the reputation management industry, and where do you think we can go?
Yes, the more I've sort of been at the bottom of it, the more troubling I found it. A lot of these law firms are working with PR companies and their wider associates, and certainly in the example of one of the very rich people who I was confronted with, there was a major law firm that was actually being paid by a supposed benefactor of the financial fugitive concerned, who had been barred financially from actually transferring money himself. So I later was able to prove that money was stolen money that was being laundered. So huge sums were going, millions were going through this large law firm into other law firms based in London and into PR companies that were, they're managing not just a lawsuit, but they're managing PR and associated, services. And if you're the journalist who's the butt or the focus of this pushback, it's not just legal cases. You're going to be facing negative PR. You're going to be facing private investigators. You're going to be facing threats. You're going to be facing hacking, and it's too connected. And I think that I'm not sure that there's enough diligence going into sourcing of money, where it's coming from and where it's going to by these law firms who are handling millions for these clients. And they actually, a number of these firms have now opened up, wealth sections. Reputation management is a major segment of the firm that not only deals with the legal aspects of things, which is their profession, but with every possible desire that this wealthy client might have, from having their kids chauffeured to school to the various aspects of living in London that they might want serviced. So you're really seeing law firms kind of just becoming the servants of the super rich, and it's really it needs looking at.
I mean, Claire said it, right? It's that they've become too connected, and suddenly a lot of these solicitors firms do PR. They've basically become one-stop oligarch shops. You know, Mishcon at a point was looking to partner with Headley, so the same firm that sells passports. And that, you know, presents all sorts of problems, becomes too mushed up. Does it affect the kind of legal advice they're providing their clients? How do you regulate them? And I think on the sourcing of fees, that's really important. So I mentioned earlier something that emerged in the public inquiry into my mother's murder, where one former cabinet minister and the former Prime Minister's chief of staff were called to give evidence. And we're asked specifically about 2 letters that Schillings had sent on their behalf to the ICIJ, so the organisation that the Panama Papers, and that my brother worked for, you know, over that league. And the letters, so there are a number of questions, right? A cabinet minister in Malta at the time was paid between 60 and 65,000 euros. And the former chief of staff about 50-something thousand euros. There's no way you're on that salary, you're going to hire Schillings. So they were asked, how did you pay for them? Why Schillings, right? There are so many lawyers in Malta and in the world, but they always go to Schillings, which is so expensive, so aggressive. Another thing about the letters is they were the same. You know, they were literally the same. They said the same things, including, by the way, that the ICIJ should consider firing Matthews, my brother. And so that was another interesting thing, I thought. Wittingly or not, these law firms, right, so they acted for the corrupt politicians and officials, the companies, the bankers in Malta. This is all in Malta. So wittingly or not, they are in effect acting for an organized crime group.
With no oversight.
With no oversight.
With a sense of total impunity. Yeah. Total impunity.
I'm aware that people who've rolled their hands up, so I would very much, like, I would agree with a lot of, we have a huge problem and we've left it for so long. And the one thing I will say is, it's quite remarkable the number of politicians that end up shilling quite literally in reputation management firms as well. I think it's a huge, you know, we have no lobbying registers what to speak of, etc., etc. So the architecture has also been constructed by politicians that allows this to go on, and many can go on to make very, very, very handsome sums of money working in the reputation management industry that they were supposed to be regulating in the first place.
Thank you. My name is Cromwell, anyone from the Emerald Isle, no relation. Some of you will know that I've been quite active in promoting this within Parliament, and I hope we're going to get some traction. I mention that because I have a bit of a challenge for you, which is, when is a slap not a slap? Because the very well-paid lawyers up against you will exploit that gap if they can. If you're going to define it, you're going to face the issue of equality in front of the law. So if you're going to say certain people aren't able to bring cases because they're bringing a slap, you're going to have to define that slap very carefully. And if we're going to produce legislation, which I hope we are, to prevent slaps, you're going to have to define what is a justifiable defense against an accusation of bringing a slap. That's a very boring technical point, and I agree with so much of what has been said on the panel. But we need to really nail this, or those smart lawyers will just run around it. Thank you.
Thank you. Responses to that?
Yeah, yes. Oh, well, yes, I think if we're going to keep the system where we retain cases in the High Court, we are putting ourselves in a position. I think we all know a slap when we see one. It usually contains a sort of bit of blackmail. It usually says, we think we could get you on this, but you know, we've gone to so many other major newspapers and they've already taken down the story. And we would suggest that you take down the story as well. And if you could erase every other mention you've ever made of our client, then we won't pursue the case. We'll cease to be so offended. So, you know, so many of the cases you get, the letters you get involve a sort of element of blackmail, where there's a clear ulterior motive, you know, that will cost you money unless, here's the deal, That's usually, but you know, I actually think you just need a completely different place. You know, get rid of the High Court and solve these problems in a place that's accessible to those who don't have this kind of money. You know, we all care about our reputations, not just the super rich. We'd all like to have justice if someone's besmirched us, and that should be done cheaply and effectively with an independent arbiter. And I think a genuine litigant, rich or not, would be happy with that as well. If they really all they're worried about is their reputation, then they'd be happy to go to a, you know, to a less elevated body and get the apology they want.
Thank you.
Yeah, Martin Bright. Now, last time we were here to talk about slaps, I kind of made a slightly light-hearted comment about warning people that their views may find their way back to the slap wars because they take a very close interest in meetings such as this. We now know this is the case, and indeed the last meeting that was held here to discuss slaps, the proceedings were reported back to Cartwright. So I'll be slightly careful about what I say. Particularly as I have here a slap letter from Cartwright. Marked private and confidential, of course. When we were here, Oliver Bullough raised the case of Charlotte Leslie, the Conservative MP, who's been the subject of legal actions from Tory donor Mohammed Mercy, and this is in fact the subject of this letter. And when we're talking about definitions, I just wanted to ask Claire, as you've used your forum, your Sarah report, to write about this case, and indeed made the argument that this is not a slap case. So, absolutely addressing the question raised. I'm curious to know why you took this approach, particularly as, I don't know if there's a connection, the free speech world has decided to distance itself from the Charlotte Leslie case. And this has been seized on by Cartwright and indeed Mohammed Mercy in their action. So considering the fact that solidarity is hugely important in slap cases, I'd just like to know, Claire, as someone that I respect and whose journalism has been extremely important, why you took this approach. When others such as Tom Burgess, Nick Cohen, Oliver Bullough, John Sweeney have described this as a slap case.
Well, I'm not sure I want to go diving into somebody else's legal case, quite what you're asking me. But Charlotte Leslie's here. She could always come and talk about it if she wants it to.
She's been slapped. No, I'm asking why you took the approach in those articles.
Well, I wrote an article about the issues, and I did 2 separate articles, and I asked each side what their position was. I didn't write about the lawsuit.
I would like to say, I have in print that interview on background information I gave us off the record, and I can provide the written evidence that I'm in very good faith because I want to help the cause, and I hugely respect the journalism that Claire has done, like everybody's audience. I decided to give an interview off the record because I haven't been on the record, because as everyone in the panel will know, I can't speak out, and I'm sure even this will be described as a rant, as my last contribution was last time to this. But I was deeply disappointed that I wasn't able to talk properly about our arrangement. I have to say to everyone, I went to IPSO because Claire, in the House of Lords, quite rightly said that defamation law in the High Court is not the right place to go, and we need a proper press regulation body, because good journalism can only come with responsibility. And every journalist I know knows that they should be held accountable to make sure that their journalism is the truth. After all, that is what we're fighting for. I was rather shocked to find that, having tried to sort out the differences between us amicably, having gone to IPSO, I found that Claire wasn't regulated by IPSO. Now, I'm not someone who's going to go to defamation court. I don't have the money. We all know I don't have the money. But I just think it points to the fact that we need a better press regulator and we all need to work together. We can't have division on this. We know in freedom of speech is peaceful. We knew in either due diligence notes or incredibly brave journalism, as embodied by everyone on the panel, is stifled by people. And I would just say we need to work together and we cannot be divided, otherwise we can't.
Thank you.
I think I've got a right to answer there. I think the important thing about this SLAP campaign is it's about journalism by and large. Your case has nothing to do with public interest journalism. Frankly, you weren't writing as a journalist. It's nothing in the public interest. And I did not. What I did not write about was your court case, which is what I assumed was off the record, quite naturally. Not well. I mean, if you want to come here and use this platform to advocate your particular case and to mug me, fine. I think it's inappropriate, and I'd be happy to talk to you off screen. But I mean, you know, I don't think it's fair to hijack this case for yourself, frankly.
Fair, and I think we're just going to have one final point, and we're going to move on to the next panel, and we can discuss after the event.
So, wow, good luck with tonight. So old.
Right, is this
No, this is like a step back point, because it seems like Groundhog Day, going back sort of 10 and more years ago. And Peter, you mentioned the Defamation Act 2013. I'm really sorry we couldn't get Northern Ireland in its embrace, but the DUP, as you know, do like a good libel suit. My name is Paul Farrelly. I stepped down as an MP in 2019, a Labour MP. I was 15 years on the Culture, Media and Sport Select Committee, and before that, an investigative journalist with Reuters, The Independent, and The Observer. And so I've crossed swords with the likes of Carter Ruck inside and outside the House, but they always overreach. They did so when they tried to remove the time-honoured ability of the press to report with privilege what was said in Parliament when I put down a question over a toxic oil spilling scandal called Trafigura. And so what's really important is that this isn't just about journalism, actually. Taking people out of the game, making their lives a misery, back then was also about them suppressing scientists and medical research. So it's more than just journalism, it's more than just reports from NGOs. The good thing that's come out of this, because they have overreached, is this anti-SLAP consultation. And I chaired the libel reform group just over 10 years ago, before the Defamation Act. And what's important that not only
everyone contributes to that, but contributes to that, but also that for the breadth of the chilling effects and the extent of the practices that we all know about to be put out there in public, that a mechanism is found for the Ministry of Justice to publish the responses of consultation, and hopefully underprivileged, so that so it's not a chicken and egg situation, so no one has to fear. And that's what I'm trying to do, discussing with former colleagues in the House.
And I think on this issue of consultation, we're going to go to the next panel now, where we'll talk specifically about the consultation itself. If I could just ask you to hold the question until the end of the event. So we're just going to do a little switch over onto our legal panel. Thank you so much.
Great.
Moving to our second panel of the evening, how to solve the SLAPs issue in the UK. We have Susan Humphreys, Project Director from Foreign Policy Institute and author of the report that's been launched tonight. Charlie Holt, lawyer and campaigns advisor to English Pen, also Greenpeace, and has been a driving force on SLAP reform in the US and Europe and the UK, so massive experience, and great to have Charlie here. And standing in for Caroline Keane, we have Adelaide Lopez, who is the Senior Associate at Wigan. Caroline unfortunately has been ill this evening, so we're delighted that Adelaide could step in at such short notice. And Adelaide most recently was working on the Catherine Belton case, which was a real win against SLAP, so we're delighted to have you. So Susan, if we start with the report, the main findings and recommendations.
Thanks, Sarah. The report is pretty lengthy. It's 100 pages, so there's a lot of findings and a lot of recommendations. I mean, I think a key takeaway is the fact that we're in a very different place from when we started writing the report, which actually was part of research that was being done for an Article 19 report on SAPs in Europe, which was just published last month. And the UK was one of 11 countries that was being looked at. And we really just started to build out the research from there and honing in on the UK and particularly London, hence the title of the report, London Calling, as a real hub for these kinds of abusive lawsuits, and has been indicated by the first panel, particularly letters. And so we were sort of familiarising ourselves with these terms, and we knew of a few cases, but I think in the last year what we've seen is a huge rise in the awareness, and we're now at a stage that it's on the government agenda, and there's a real chance, hopefully, at least the potential there for reform, which is, I mean, it's almost night and day to last year. So I think there's a few factors for that. I think there's been some very high profile cases, including that of Catherine Belton, which I'm sure we're going to hear a little bit more about, who was aggressively pursued by several Russian oligarchs and, of course, Russian oil company, Kremlin-backed oil company. And, you know, I think that really sort of shot already up the agenda last year, but of course puts everything, the current war in Ukraine obviously puts everything in fresh perspective. And you can kind of understand why, you know, these legal threats and potential for them to shut down or remove information from the public domain can be so concerning and basically delay you know, potential redress. I think the key kind of point to focus on, and again, I think this was covered in the first panel, is that the court cases like Catherine's, like Tom's, like Carole Cadwalladr, who went to trial in January and still waiting the judgment, but also people like Claire and Paul, they're just the tip of the iceberg. These are people who are incredibly tenacious and have stuck the course in order to defend these cases, but not everybody is in the same position to do so. And the inequality in arms and you know, the balance of power that we've been talking about, that just comes up again and again in the cases that are examined in this report. And that's why it's successful. And so we really need to address that, and I think, you know, Charlie's going to talk a little bit more about how that might look in terms of legal reform. But there are other elements within the recommendations as well, looking at the facilitators of these legal threats, who kind of, I think again, as the first panel mentioned, operated with pretty much no oversight and you know, impunity, for want of a better word. And I think that's exactly, you know, the intention. These letters are sent out, smart, private, confidential. Journalists are very fearful talking about them. When we started the research, I approached journalists and sort of said, "Hi, would you like to talk to me about legal threats?" And unsurprisingly, a lot of them were like, "No," because you know, they were afraid. And that's on 2 points. One, if they had you know, given in, nobody wants to talk about that. That's quite shameful. That goes against the instincts of journalists. And then the other side is, if they've got through it, if they've managed to deal with the legal threat, they don't want to open that up again. So I'm very thankful to the journalists, like those who've spoken on the panel, but others who have gone on the record and have talked about it, because I think we have already seen that the sort of public spotlight has resulted in some of these cases just evaporating, which goes to show how hollow they were in the first place. So yeah, I think Charlie's going to talk a little bit about the law, but other recommendations in the report were really around you know, raising the awareness of this. If you're a journalist yourself, you know, report to the SRA. I know there have been troubles with that so far in terms of those who have done it have felt it's insufficient, but we need to get these cases on the record. The government consultation right now gives that opportunity. You can write to them in confidence, submit that information by the 19th of May. And we really have a chance here to raise that awareness, to push for the momentum of change and put the spotlight back on those who are doing the enabling and also the claimants, because so much of what happens in this process is that the focus goes onto the journalist, right, and not on whatever was being investigated in the first place. And I think we need to turn it around. Thanks.
Turning to Charlie. Charlie, I wonder if you could explain a little bit about the work of the UK Anti-SLAPP Coalition, which has really gained huge momentum since it was established by you and Susan and Jessica Index about a year ago.
Yeah,
last January. And also to talk about the model directive, model law. We have model directive at the EU level, at the UK level. What are we looking for in terms of legal change?
Yeah, well, it'll be a real pleasure to present the work that the working group's been doing over the course of the last year, but it'd be massively cheeky if I did so without first acknowledging that it was actually Susan who brought us all together at the beginning of last year. I was, as you say, Sarah, busy working with you on the European level, and I only came in as co-chair in, I think, this time last year. Yeah. Actually, this time last year, when we started working on this, we already had a very clear idea of the problem. I mean, there are, I see journalists here who have been writing extensively on this. There are lawyers who have been working on this, journalists, all sorts who have been talking about this for a long time. And of course, Susan's reports and research, which has been so crucial in giving us a clear understanding of the problem. What we lacked was a clear and coherent overview of the solutions. And that's that became the first focus of the working group. And so around this time last year, I think in May or April, we published a policy paper. And the policy paper, the first question it asked was, well, what are the conditions which give rise to SLAPPs? Why is it that London is such a magnet for SLAPPs, whereas in Sweden, for example, we didn't have one identified SLAPP in Sweden? Was it something in the pickled herring which made the rich and powerful more tolerant of free speech? Maybe, but the conditions that we identified weren't just cultural conditions. They were legal conditions, they were procedural conditions. And so that's the first thing we identified in that process. But anti-SLAPP laws work by filling the gaps in procedural protection, which is so effectively exploited by SLAPP litigants. It's these anti-SLAPP laws which seek to repair some of the deficiencies which SLAPPs feed on. And so it really came down to this idea of an anti-SLAPP law. And so once we had this policy paper in place, we set about trying to flesh out the legal parts of it. And we did that through 2 roundtables, which we convened last year. I should say first that we didn't start from scratch here. There are 34 anti-SLAPP laws that exist in the US alone. There are 3 anti-SLAPP laws in Canada. There's an anti-SLAPP law in Australia. So we were able to start with a comparative analysis of what worked, what already worked around the world. And in that process, we can already extract what is good and mitigate what is bad in those anti-SLAPP laws that already exist. And I think we went in there with an open mind. We recognize that in some anti-SLAPP laws in the US, that they've gone on to operate in some cases, in some ways which weren't intended. A number of anti-SLAPP laws have been amended to address some of the problems. In some cases, anti-SLAPP laws have themselves become an instrument of abuse, and those have since been repaired, those deficiencies. So we had a lot to go on, and I'm sorry if I'm going on too long, but I think when we once we had this, we were really able to distill 3 main principles which were underpinning all of the different laws that existed worldwide. And the first one was that SLAPPs needed to be disposed of as quickly as possible. The second was that costs for SLAPP targets needed to be minimized so that as little harm could be caused to those SLAPP targets as possible. And finally, that the costs for SLAPP litigants had to be high enough to deter others from using these tactics. And that was from those 3 principles, we were really able to then ask the next question, which is, well, to what extent do we need a new law? To what extent can we use existing mechanisms? So, for example, to some extent, the use of the existing motion to strike can be used to get rid of abusive claims quite early on. So, one question that is often raised is, well, can that just be used more frequently? So, while that's theoretically possible, though, the courts have interpreted this idea of an abusive lawsuit very narrowly. And so it could only ever, the use of a motion to strike could only ever be used to scratch the surface of the problem. And so we recognized pretty early on, therefore, that there needed to be some statutory underpinning to empower courts to be able to get rid of cases, get rid of slaps on a more regular basis. I think another problem that we come across is that it's very difficult to identify a slap intent, malicious intent. And I think this is an important point here, because there can be legitimate disagreements about what constitutes public participation. There can be legitimate disagreements about whether someone has filed a lawsuit with the improper purpose of silencing speech. We can have debates about individual cases if we want, and that's exactly the problem. If you have a law which requires people to identify that subjective intent, then it's always going to be underused. So with any anti-slap law, you need to have a higher threshold. You need to have an objective test. So any claim which targets public participation would need to be subject to that higher threshold. So that's one part which our analysis identified very firmly, that we needed to have an early dismissal mechanism which included a higher threshold which such cases needed to meet. And secondly, and I don't want to go on too long, but I'll just say two things very briefly. We also need to have, firstly, a robust regime of sanctions, and we need to have protective measures for those who are targeted by slaps. And this means addressing the elephant in the room, which is costs. Again, going back to existing mechanisms, a lot of people will look to the UK and they'll say, well, unlike in the US, we apportion costs after the case, according to who has won the case, the loser pays principle, which differs from the US. And they'll say, well, you don't need to have a system of sanctions. But again, that is wholly insufficient to rely on costs after the event. Most people who don't have money can't look towards a hypothetical recovery of costs at some undefined point in the future and say, well, therefore, I can afford to fight this case, because they don't have the funds then to be able to defend the case. And so more often than not, they will retract and apologize, which you see time and time again. Secondly, we were talking about slaps as being most often used by the rich and powerful. So you've got to look about what is going to deter the rich and powerful from using this. It's not going to be just them paying the other side's costs. There needs to be sanctions in place which are sufficiently high to be able to address those people, the rich and powerful. So we need to have a way to financially support slap defendants, whether that means the establishment of a fund or if it means expanding the eligibility of legal aid to include those targeted by public participations. It doesn't matter. There just needs to be that mechanism in place to provide financial support. I'll stop there. We're in the process now of really trying to flesh out these different ideas into a single anti-slap law. We've already had some support from brilliant lawyers such as Rupert over there in the audience I can see, and Caroline from Wigan. But we really are welcoming feedback from others. So I'd say if there's anyone here who would like to see this, who can help us with reviewing these and giving some feedback, it would be warmly welcome. But in the meantime, I just say watch this space for other work that's going to come.
That's truly. And I think it would be great if we could come back a little later to the points raised by Lord Cromwell around access to justice and these questions of when is a slap, not a slap. But I think this wide definition is kind of key. Adelaide, I wonder if we could also look at, from your experience defending Catherine Belton, and your experience as a lawyer here in London, what are other reforms that you could see that would be helpful from within the legal industry? And
yeah, I mean, it's despite the accent, I am a lawyer here in London, and I do practice English media law. And I think it is tricky, however, as an American who's practicing British media law, because I am raised on the First Amendment. I am raised on the balance of the burden of proof being on the claimant rather than the defendant. And so, if I had my druthers and could walk into Parliament and have one thing I could do, it'd probably be to shift burden of proof. That's not happening in my lifetime or anybody else's lifetime. But I think that there are some very key changes that could be happening on a sort of a micro level that could make all the difference to how cases proceed through the courts. Because I think it does go back to this question of when is a slap, and I think it is sometimes a difficult call to make. And so what you have to start with is, well, it shouldn't necessarily be a subjective thing. It should be how does the case proceed through court. And so one of the first questions should probably be if it is on its face public interest journalism, if that can be determined at a preliminary stage, such that you don't end up with the journalist and the publisher and the journalism being on trial, then you could actually help a substantial number of these cases that are like Catherine's case, that are like Tom Burgess' case, where you have clearly, especially when we see everything that's happened with Russia at the moment, we have something that is so clearly in the public interest to expose what was happening in Putin's regime, that can be dealt with at a very early stage, as opposed to dragging the publisher potentially through what could be millions of pounds worth of costs. If that could happen at an early stage, like meaning is determined at an early stage, then you could help a large number of these sort of clearly public interest cases. But in addition, there are elements that were already introduced by Parliament, such as the serious harm threshold, which has really gone through the ringer the past few years, as claimants really did try to sort of pervert what Parliament had intended and took it all the way up to the Supreme Court, and we had the Supreme Court say, no, it really was intended to be a threshold issue. However, even though it is a threshold issue as to whether or not somebody suffered serious harm by the publication, it is still not determined until trial. So it's a threshold issue, but it's not heard as a preliminary issue. And if it could be given its actual due and actually be heard as a preliminary issue, particularly when you have businesses that are brought that bring claims and really should be forced to say at the very beginning that they've suffered real financial harm, which is what the Act says, then you could also cut out a whole swath of businesses that are bringing absolutely ridiculous claims and really bringing in real slap suits against journalists and publishers. After that, you have a lot of very, very technical rules, like the repetition rule, which says that if a defamatory statement has been made by another publication, then it cannot be considered as a defense against your current publication that's being sued. And that was fine at a time when you were talking about idle gossip. It seems less appropriate a time when you have publications that are online, that when you have a 24-hour news cycle, when you have news that is being published by a whole variety of journalists and reporters, and to say that the fact that story has been researched and covered by somebody else shouldn't have some impact on whether or not you're liable for that publication just seems ludicrous in our current news environment. Equally, there is Caroline's favorite topic to discuss, which is the rule in Dingle. I think mainly because she likes saying the word dingle. And it goes hand in hand with the repetition rule, which says that even if somebody else has written about it and there's been some damage caused reputation faced by this defamatory statement, that damage shouldn't be somehow discounted against the damage that's been caused by your publication, which also seems ridiculous because you're talking about a double recovery for publications that have said the same thing. These are sort of, they're very technical, as I say. They're seemingly sort of minute details, but they really do make a difference. And we have actually seen in recent in recent reform, when you had the cost reforms that came in, where the CFAs and AT insurance and the reforms that happened there caused a lot of the kind of ambulance chasing claimant firms who were going after not the rich and powerful, but they would see an article in a tabloid about a plumber whose wife had cheated on him with her best friend, and they would go and they would say, you know, you probably have a defamation claim, I'll work on a CFA. And so you end up with these sort of ambulance chasing claimant lawyers who were just bombarding publications over and over and over and over again with these small suits because they knew they would be settled quickly and there would be some kind of payout. And it was just a machine churning constantly. And once you had these reforms put in, they just stopped. I mean, almost overnight, they didn't have, their business model just completely evaporated. So these may seem like technical, boring reforms that don't make any difference, but they actually do have a real impact. And so I think that if we can get if we can get these little reforms into place, they actually could make a very big difference. They would fall short of completely shifting the burden of proof, but it would still make me happy if we could at least get that done.
It's a great place to start, and now is the moment. I think that's really been the resounding point, is that we have a momentum that we never expected to have, both in Brussels and here in London, and we're looking at a pretty quick reform, and I think that's why we've had such a scramble as well to really try and get ahead of where the government is to ensure that we're able to provide them with good model rules. Charlie, coming back to the questions and concerns around access to justice, how would you answer those questions? Because those are the concerns that most politicians are going to bring up.
Well, of course. I mean, I'd say a couple of things about this. I mean, the first thing I'd say is to try and remember that what we're dealing with here is abusive lawsuits. They are lawsuits which are filed with the improper purpose of silence and speech. So even by existing standards, these are lawsuits which have no place in the court system. You know, the difficulty is about identifying that improper purpose. And so what we're really doing is trying to create mechanisms by which that purpose can be identified, or which these lawsuits can be easily filtered out of the court. And that's the first thing I say. The second thing I'd say is just to emphasize about whose access to justice we're talking about. I think the point has already been raised that this imbalance of power between the defendant and the claimant is really inherent in the concept of a slap. But slaps have the practical effect of squeezing people out of the court system. It just happens to be the defendants. And what tends to happen is that when defendants who don't have the money to be able to sustain that fight look ahead and see a long, protracted court process, they will retract, they will apologize, and they will not report any further on that particular person, that particular story. And they won't be able to have that fight. They won't be able to sustain themselves in the court process. And that in itself represents an impediment to access to justice. So I think it really is important just to think about what that expression, access to justice, means, and its implications for both sides.
Exactly. I wanted to open to the floor. We have Nick at the back. Mike is great for our online viewers.
Hi. Do you hear me?
Yes.
Yeah. Look, I cannot emphasise enough the importance of the point about the costs of the English law. It is, in France, a libel case costs £10,000. And what matters is the verdict. In Britain, I don't even want to back me up on this, but HarperCollins told me that if it had lost the cases the Russians brought against it in Britain and Australia, which is curse of our legal system, it would have cost them £10 million. You know, it is the cost of the law that is denial of access to justice. The libel reform campaign, which Paul and I were involved in, we failed because we did not understand that the English law is a luxury good sold on the global market with prices to match. Now, it was said by a speaker on the previous panel that slaps only affect journalists. What nonsense. It is absolute nonsense. The National Crime Agency lost a unexplained wealth order case against the family of a Central Asian secret policeman who somehow managed to buy millions of pounds of property in London. That the cost £1.5 million, it wiped out their annual budget. What these firms are about is asserting power. If you just say, we want something to protect journalists, the public, first of all, journalists are citizens like everyone else. Who is a journalist these days? Someone on Twitter, me, someone writing a blog. You can't even define a journalist these days. The cost of the law in England and Wales needs to be radically reduced for everybody, for every citizen. And that will mean if the Daily Mail or the BBC's lie with you, you're not scared by the cost. You can go to court for £10,000 rather than £1.5 million. The final point I want to make, because I appreciate some people in the room may not understand what's going on. If you want an example of how slaps are about power, I refer you to the case of Charlotte Leslie. She can't speak for herself because she's been absolutely battered with hundreds of letters, threatening letters from Carter Ruck. She has had a PR agency, the Phil Hall PR agency, whose founder is a former editor of the News of the World, to give you some idea of the morality involved, hired to direct propaganda. Like other people, like my colleague Tom Burgess, there are signs that security companies have been going after. With the super rich, you're not talking about just libel, you're talking about privacy, you're talking about data protection, you are talking about the most expensive barristers and solicitors and lawyers earning their fees by any means necessary. Now, as Charlotte can't speak for herself, I will say, and everyone, we have to be so careful in our own country of talking about Tory party donors and the super rich. For the record, Mohammed al-Mursi had a court judgment against him in 2000 saying his testimony was wholly unreliable. A Swiss tribunal found in 2005 that he had profited from deals with an associate of Vladimir Putin. The Paradise Papers found that he had acted for a Swedish company that had sold telecoms deals to Uzbekistan by paying off the dictator's daughter. He's donated, and his wife have donated, millions to the Tory party. And finally, Private Eye and the Financial Times, both newspapers I trust, said that Charlotte wrote a private memo pointing out that it appeared on social media the person he wanted to put in charge of a group representing the Conservative Party in the Middle East, one, the most politically sensitive region in the world, two, awash with dodgy oil money, was in fact the daughter of a Russian banker. And I think, one final point, I'm sorry to turn to an Old Testament prophet here, but when the truth about what's happened to Charlotte Leslie comes out, and I believe it will, there'll be people in the anti-SLAPP movement who feel ashamed of themselves for the way they behaved.
Hi, I'm a legal advisor at Protect. The panel has talked on the Defamation Act 2013 reforms, and the government call for evidence is focused quite heavily on the Defamation Act reforms. Or potential reforms. I wondered if, in light of the judgment in ZXC and Bloomberg, the fact that vindication for reputational damage may now be sought through a privacy action, if the damage to reputation is serious enough that it might engage a claimant's articulate privacy rights. Does Parliament need to consider legislating to introduce a serious harm threshold for privacy action, for example? And do we need to focus and make sure we're not myopic in focusing only on defamation as the cause of action brought in SLAPP lawsuits?
Yeah, sure. I mean, I completely agree. And I think that's an important point. SLAPPs can take many different forms, and they can weaponize a variety of different laws. And in fact, as also has been commented, once the Defamation Act 2013 was passed, SLAPP litigants looked elsewhere, and we did see a rise in other claims. You mentioned privacy. I can also mention data protection laws, breach of confidence, trespass, protection against harassment acts is a good example. I think Nick's colleague George Monbiot wrote a lot about that in The Guardian. There are a number of different laws which have been weaponized. It's important to do that. And I think when we were talking about the anti-SLAPP law growing up, most of the provisions are universally applicable. They apply to all laws, and they're really concentrated on looking at procedure. So I mean, I do think there are ways to do that. Turning specifically to the idea of looking at reforming privacy law, I think privacy law, part of the problem is that there are this myriad of different laws which apply when you talk about privacy. So I think one of the things that needs to be potentially done is to clarify and consolidate and codify that law. I think at the very least that needs to be looked into. But otherwise, I'm wary of just providing more material to the government, because I do think a lot of the Human Rights Act reform now is a little bit spurious than what they're saying about grounds. Because of course it's about the abusive application of laws.
Yes.
We
have a gentleman on the sofa.
Hi, my name is Henry Williams. I'm head of investigations at FEMIS, and we help firms deal with financial crime. One of the big things we deal with is the financial sector, and they've got very well rehearsed laws regarding source of wealth and source of funds. HSBC got fined £64 million for failures on its source of wealth, source of funds checks. If we're talking about killing the business model, Roman Abramovich admitted in court that he made his wealth in a rigged auction. That is a massive failure on source of wealth. Surely the people who are representing people like him should go down. Again, on source of funds. In a previous life, I was a private investigator working against some nasty oligarchs. Again, some probably rather unlovely people myself. But the big way to kill their defence was always to go after their source of funds. It invariably came from British Virgin Islands Company, which has passed their money laundering schemes. So I really want to understand how Carteret and Shillings can continue those business models, given where they're getting their money from.
If we take just two more and then go to the panel. Gentleman in black.
Thank you very much. I'm a former UK law enforcement intelligence analyst covering the ex-Soviet states. I would just say almost everyone here is aware of the significance of Catherine Belton's book. Believe you me, if you read the supposedly fictional Command Authority by Tom Clancy, you will see just how staggeringly important Catherine Belton's book is, and that kind of thing has to be published. My question is, what are the strengths and weaknesses of Australia's system, given that it is, of course, English common law system? Thank you.
Hi, I'm Sian Harrison. I'm the law editor of the Press Association, so I cover a lot of these cases. And I'm really sorry to raise the kind of spectre of crowdfunding, but there have been mutterings about potentially reining in the use of crowdfunding, and it's obviously something when we're talking about access to justice that some people who have been hit with this kind of litigation have used. So I just wondered if anyone has any views on crowdfunding and whether or not it, should continue, or what the potential for closing it down that's being discussed is, and whether we should be worried about that.
Great. So we have source of wealth, Australia, and crowdfunding. Give it a shot.
Can I just say one thing about the crowdfunding thing? I don't want to hold the mic, although it is on my head, so half help. Just on the crowdfunding, but there's a really interesting case in Germany. Do you know the group Some of Us? Yeah. Yeah. So they were sued by PayPal because they ran a campaign about PayPal facilitating funds between neo-Nazi groups. And Some of Us had a van which went round in circles, which had a sign saying PayPal stop funding Nazis, just went round and round and round. It was wonderful. And PayPal sued them, and I think launched a criminal complaint. Some of Us responded with a crowdfunding campaign. And 2 weeks later, the case was dropped. And I think it's an important case because I think there was two things. One, of course, is it showed huge support. It showed that they were willing and they had means of raising funds. But most importantly, it doubled up as a means of exposing the litigant slap, and really naming and shaming the person, the group that was responsible. So it had a double purpose there. So I think it can be really, really helpful for both those reasons. But of course, SLAP targets shouldn't have to rely on crowdfunding. It tends to be those groups who have a high profile, like some of us, who can take advantage of that. And those people who don't have that same profile will struggle with that. I don't know if there are other questions.
I don't practice in Australia, but it is no secret that the Australian courts are incredibly claimant friendly. If we were to talk about somebody mentioned earlier about the costs associated with Catherine's case, I can't speak to, I could hypothesize on what the cost could have been at the end, and they were incredibly high. If it had gone all the way through to trial, it would be incredibly high. But a big part of that would have been Australia. The big fear was if that did go ahead, because even though there's really no reputation for Roman Abramovich to have that he has in Australia, apart from the sort of tangential relationship he has by way of Chelsea, he still this specter of what the damages award could have been in Australia is so powerful that it really does overshadow potentially all else, even the costs associated with the English system. So in terms of what reforms could be had there, I can't speak to that, but it certainly is something that is of very considerable concern, even over here.
I could just note on the Australia point, the Central Australian Territory has an anti-SLAP law, but it's notoriously rubbish and underused. And it goes back to what I was saying before about the difference between a subjective and an objective test. So Australia's, I think it's a separate, I'm no expert, but I think it's a separate cause of action we can launch against those who have filed a lawsuit for an improper purpose. But of course, that requires establishing that improper purpose, which we said is extremely difficult to do. And so there is an anti-SLAP law on the books, but it's an example of where anti-SLAP laws don't necessarily work and the need to get this right.
Yes, source of wealth. I think it's pretty critical. A lot of the recommendations that we made in the report actually link in with making sure it's clear the role that SLAPs and legal intimidation play when it comes to anti-corruption efforts and trying to uncover illicit source of wealth and how those two things interconnect. One of the cases that features in the report is that of Paul Radu, who's the co-founder of OCCRP, behind many of the sort of global investigations like Panama Papers and various laundromats. The one that he got sued for in the UK was the Azerbaijani laundromat, and that case took place over a couple of years. It finally settled in January 2020 when the claimant decided to withdraw basically on the eve of the trial, and made a settlement in favour of the journalists. The information stayed online. But what had provoked that was that during the preparation for trial, there was a disclosure process where both sides had to give information to one another, and clearly the claimant had second thoughts. The reason for that might be pretty clear now, because at the start of this year, the National Crime Agency seized, I think it was around 5 million from his family members, and that information that had led to that asset seizure had come both from the original Azerbaijani laundromat investigation, plus information that the NCA had obtained through through that legal process, in fact. And so, coming back to the law firms, I mean, not all cases are linked with financial crime and corruption, but clearly there is a strong motivation if you have done something wrong and you are, pretty deep in pocket of lots of dirty money, that you'd be strongly motivated to use that to shut down any inquiry into where you got it from. So we, need to be pretty sure that those law firms are not in the receipt of the funds, which is, proceeds of crime is a crime. But there needs to be more oversight of that, and funding, effectively funding anti-corruption measures and enforcement. They're tied together because ultimately they also law enforcement agencies rely on the information that journalists bring to bear and bring out through their investigations. So it's pretty crucial that they're recognised, and there has been in some places in the US. They updated their anti-corruption strategy in December and recognised SLAPs and that role. And I think the UK could do more here. There have been efforts in Parliament to make that. In the recent economic crime bill, there were several MPs and laws that put forward amendments trying to raise it. Haven't seen it adopted yet, mainly because the consultation's ongoing at the moment. But I think that's pretty clear. That we need to address these issues together.
Yes.
Yeah.
Thanks, Susan. Just one final round. A response from you, gentlemen, just at the back, patiently had his hand up. You, yes, yeah, orange shirt, yes. And then we'll close up because we're out of time now.
Hi, I'm Ed Siddons. I'm a reporter at the Bureau of Investigative Journalism, where we're doing some work on oligarchs and naughty people in suits. One of the things that we found in kind of a lot of the economic crime stuff is not so much the laws. The laws themselves are quite strong, but it's precisely this question of enforcement. So let's say, hypothetically, you get this amazing anti-SLAPP legislation through Parliament and swiftly. Are you concerned about the enforcement thereof? Would it come down to the SRA? And do you think that the SRA in its current form either has the capacity or the competence to effectively enforce any changes to legislation?
No.
No, they're not good. I think that if anything's going to have a powerful impact, it's actually going to be the current sort of PR campaign that is very effectively naming and shaming a lot of these solicitors. I feel for them personally because, I mean, having the most recent being a U.S. senator naming them and saying that they should be blocked from entering the U.S. Altogether was a pretty punchy move. But I think that is probably going to have more effect than anything the SRA is going to do anytime soon.
I would just mention that they have, for the first time now, put SLAPs in their guidance, which is not strong enough by any means, but at least it's a recognition of the problem, which is always the best first step, right? But yeah, definitely the regulators need to do more, and there needs to be real penalties for those that are enabling this kind of. It can't just be a slap on the wrist. It really needs to be something more serious to be a deterrent.
Yeah, I mean, I just say on that. I mean, the legal profession is a self-regulated one, and I mean, absolutely more needs to be done. The anti-SLAPP law probably won't contain measures which will directly impose regulations on lawyers. I just go on this point, which I think was so interesting about in the US, the letter tend to be Lincoln, which was suggesting visa bans. What we thought was so interesting was the response to that from the solicitor law firms, which I thought really underscored the gaping divide between public ethics and legal ethics. Because I mean, like, the response that you got was saying, no, well, we were acting in compliance with the rules. And they could reasonably say that they were acting in compliance with rules. But any reasonable person wouldn't look at the conduct, their conduct, look at what they were facilitating and think, yeah, that's ethical. No one really thinks that. And I think what that shows is that the code of conduct as it is probably needs to be reformed. What is probably that a number of these law firms didn't mention, of course, is that a number of them have been subject to complaints to the SRA, and that those complaints haven't been upheld. And I think that to me doesn't mean that their conduct was ethical, because it quite clearly wasn't. It means that the code of conduct itself is not fit for purpose. And I think that needs to be looked into, that there need to be amendments to the existing code of conduct to the FAR standards for to actually address this problem, because it's wholly insufficient to, for example, rely on deception or this very ambiguous term of lack of integrity. Susan mentioned these documents that exist, like the conflicting duties and litigation document, but they're just flimsy bits of paper that the lawyers can wave in the air. If the SRA, if there are not provisions which exist which are unambiguous enough to actually enforce them.
That's Charlie. Would you like to respond? You're okay? It's moved on. Rupert.
One question, just I mean, thank you. That was super interesting from all of you. I'm Rupert Cooper-Coles. I'm a media defence lawyer, and so I'm really interested in the thoughts. Just looking a little bit beyond, hopefully we land a statute along the lines that's being proposed, and hopefully that has a real deterrent effect. But has much thought been given to how we keep transparency up in the longer term once Ukraine is over, once the public discussion moves on? I mean, one, I'm sort of thinking back to the sort of super injunction scandal, which I think Paul was involved in, and the Ministry of Justice brought in reporting requirements to sort of keep an eye on it. There's new guidance, and one thing that I think in all jurisdictions would be really useful is now that this problem is out in the open, we work out a way where we document it and so that this issue stays on the agenda. But I just wonder if anyone on the panel had thoughts about that.
Well, there was a lot of attention. I mean, Russia's invasion of the Ukraine has certainly shone a light on this, but I think there was a considerable amount of attention on it prior to that. And I think that if anything, even if we went back to the level of attention we had before the invasion, we would still be, we seem to be in a moment, we seem to be in the zeitgeist around the sort of rich and powerful asserting themselves at the expense of transparency. And I think that is that moment is not going to go away even if Russia does retreat some. And I think that moment is very much here to stay. I think it's a generational moment. I think it's a moment that's looking at corporations. I think it's looking at social media companies. I think that it's a call for transparency that is beyond just Putin. And so I think that it is something that's here to stay for the moment. But that shouldn't make any of us complacent. I think it means everybody needs to continue to sort of put this front and center of all of their agendas, whether it's in Parliament or whether it's in the press, and it's something that has to continue for that reason.
Final thoughts? I mean, from my perspective, it feels like there's been a shift, and I'd like to think it's one that you can't walk back from. And I certainly think that Russia has put a spotlight on Russia's invasion of Ukraine. But I think, as Sandra was saying, there was already a build-up, and there were already people thinking about this and ready to kind of bring these recommendations forward. And so we just really hope now that we've got the knife on it, that we make sure that the laws get changed and the regulation gets put in place before it moves on.
Just I mean, I think it's important to note the anti-SLAPP law, if and when it comes, it's not going to be a magic bullet. But as long as we have these astronomical legal costs, as long as you have this wide disparity of power between the claimant and the defendant, you're going to have SLAPPs, which means that we need to have this cultural shift. And I think that's really important. I think we're starting to see it now. And I think that what we've seen, the attention got, this letter in the US, all of this will contribute to that, but it needs to be permanent. And so I think there needs to be, for example, in law schools, there needs to be a willingness to challenge law firms. We're starting to see that actually in the US. There's a law firm, Gibson Dunn, and a number of law schools have organized protests outside of their events on law schools. And I think that's important because you're taught when you go to law school, you have a certain a number of standards that you have to memorize and learn. Lots of people fail legal ethics, lots of people complain about legal ethics. There's nothing in legal ethics about SLAPPs. And until there is, it's really not going to be that real systemic shift that we need.
Thanks, Charlie. So we'll leave it there for tonight. We're a little run over, but thanks so much for your patience. A warm round of applause to the Adelaide. Very much to Justice for Journalists and to Wigan for their very generous support. And please do download and read our report. You can find it on the Foreign Policy Centre and Article 19's websites. Thank you so much.